Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations for JW exam. Be ready for the passage. Start. This appeal has been filed under Section 28 of the Hindu Marriage Act 1955 against the judgment and decree dated 9/1/1998 passed by the Additional District Judge Number 1 Bharatpur in Civil Miscellaneous Case Number 14 of 1996, dismissing the application submitted by the appellant under Section 13 for the dissolution of the marriage. Stop stanza. The brief facts giving rise to this appeal are that the marriage between the appellant husband and the respondent wife took place on 3/12/1992, and it is urged in the petition that on or before 21/2/1993 the respondent wife tried to pour kerosene oil on herself to immolate but was prevented by the husband appellant with great difficulty. Stop. On the next day, that is on 22/2/1993, on information having been sent by the appellant to his in-laws, the brother of the respondent wife and her brother-in-law came and took her to her parental home. Stop. It is alleged that the respondent used to behave in an abnormal manner, and it is further alleged that even prior to her marriage she suffered from mental disorder. Stop. In the petition, it was alleged that the appellant made an enquiry and came to know that even prior to the marriage the respondent wife was being treated for the aforesaid ailment. Stop. It was also stated in the petition that the respondent was treated by Dr. Madhuvan Singh in his hospital for the aforesaid purpose. Stop. It is submitted that on 17/2/1994 the respondent was taken to the hospital, and looking to her ailments it was impossible for the appellant husband to continue the marriage, and hence on the grounds mentioned in clause within bracket 3 of section 13 within bracket 1, that the respondent being incurably suffering from mental disorder of unsound mind, the decree for dissolution of marriage was sought by the husband appellant. Stop stanza. The respondent filed a reply and denied the allegations. In response, the respondent filed her reply and alleged that the husband appellant used to treat her with cruelty because of the fact that sufficient amount of dowry was not given in the marriage. Stop. It was alleged in the reply that the husband treated her very badly and even poured kerosene on her body to burn her. Stop. She denied that she was mentally unsound or was treated for this ailment. Stop. She also submitted that as a result of the marriage she gave birth to a girl child. Stop. It is further alleged that she was subjected to ill treatment on account of having given birth to a girl child and was driven out of her home. Stop. It was submitted in the reply that the husband and her in-laws told her that she could come back only if she came with rupees 20,000 in cash. Stop. She denied that had left her matrimonial home without reasonable cause. Stop. In the reply, she stated that she is willing to stay with her husband in case her in-laws gave her guarantee of security for her life and that of her child. Stop. It was thus prayed that the application be dismissed. Stop stanza. In support of her claim of bona fide requirement of the demised premises, the landlady in her deposition as AW1 has categorically stated that the tenant had shifted his residence from the demised premises finally to a new residence consisting of two rooms located at the backside of his dhaba. Stop. AW5, the mother of the landlady, corroborated her testimony. Stop. The rent controller and the appellate authority rejected the claim of requirement of the premises in dispute made by the landlady on flimsy and intangible ground, holding that the landlady was residing at Mohali. the place of her posting as a teacher in education board stop stanza. It was the specific case of the landlady that she in fact was residing at Mohali in one room because of her employment as a government servant, and occasionally she used to visit Ludhiana to look after her mother. Stop. It was established by the landlady that had she got the possession of the demised premises from the tenant when he had shifted to his new residence located at the backside of the dhaba, she could have immediately occupied the premises and started living alone with her old mother therein. Stop. It is her evidence that had she got the vacant possession of the demised premises, she would have commuted from Ludhiana to Chandigarh to attend her official duties, as the distance between these two places is neither far off nor time consuming. Stop. The tenant could not rebut and controvert the acceptable evidence of the landlady on any material aspect. Stop. On the contrary, it finds stated in paragraph 10 of the order of the rent controller that the tenant and his brother was appeared as RW7 and RW8 respectively have admitted the said statement of landlady. Stop. The rent controller and the appellate authority rejected the claim of the landlady on the point of bona fide requirement on the ground holding that the mother of the landlady is the owner of one more house at Ludhiana, which was in occupation of the brother of the mother of the landlady, and the house could be shared by the landlady and her mother. Stop stanza. During the course of the hearing of this appeal, the landlady has admitted before this court that she has since retired from the government service, and presently she is residing with her sister at Chandigarh, and now she intends to reside in her own house at Ludhiana. Stop. It has been proved by the landlady that her mother, being an old woman, has to be looked after by her in her house at Ludhiana. Stop. The evidence led by the landlady clearly proves that the tenant had stopped living in the demised premises, and as noticed above, he had shifted to his new residence located at the back of his dhaba. Stop. The landlady categorically stated in her statement that a house owned by her parents located is unfit and unsafe for habitation of landlady and her aged ailing mother. Stop stanza. Mr. Raj Malhotra, learned senior counsel, appearing on behalf of the appellant, would submit that the division bench of the High Court committed a serious error in passing the impugned judgment insofar as it failed to take into consideration the importance of holding a physical test before preparation of the select list. Stop. The learned counsel urged that arbitrariness on the part of the selection committee is apparent from the fact that the order of holding tests was pushed to the background. Stop. It was furthermore submitted that the division bench of the High Court did not assign sufficient and cogent reasons for interfering with the well considered judgment of the learned single judge and proceeded to modify the same without any application of mind. Stop. Our attention was moreover drawn to the fact that the purported reasons for modification, which were enumerated in paragraph 12 of the impugned judgment, really contain the statement of facts, and thus the same is wholly unsustainable. Stop stanza. Mr. P. K. Goswami, learned senior counsel, appearing on behalf of the private respondents, on the other hand, would contend that the appellant, in the facts and circumstances of this case, must be held to be stopped and precluded from raising any contention with regard to the validity or otherwise of the procedure for selection adopted by the selection committee as he had participated in the selection process without any demur whatsoever. Stop,